everyone, I am Naren Ilyana, and today I will be introducing as well as explaining to you what illegality is. So illegality is a concept in contract law where a contract is made for an illegal purpose which is forbidden or violates the law. This causes the contract to be deemed unenforceable even when the other relevant requirements for a contract such as the offer, acceptance, consideration, and mental capacity are present. A more detailed explanation on illegality would be when the law prevents the formation of the contract that the parties have attempted to enter into, or in another scenario, the law does not prevent the contract formation. However, the execution of the contract would inevitably entail the performance of an act prohibited by law. There are three types of illegality in contract law which the courts will not enforce the contract. First is when contracts are entered into which are expressly or impliedly forbidden by statute. Second is when the contract is entered into with the intention of committing an illegal act. And third is when it is entered with no unlawful intention but is then performed where there is an unlawful purpose or object. Obviously, there are consequences when entering into illegal contracts. These consequences include the contract being deemed unenforceable by both parties, recovery of money and property that has been transferred under the illegal contract may be assisted by the courts. However, there are complex principles when the courts do so. There are two general rules regarding illegality. First will be that the courts will never ever enforce any type of illegal contracts. This rule has originated from the case of Holman versus Johnson, where Lord Mansfield held in his judgment that the principle of public policy is this: ex dolo malo non oritur actio. No court will lend its aid to a man who finds his cause of action on an immoral or an illegal act, if from the plaintiff's own stating or otherwise the cause of action appears to arise ex turpi causa, or the transgression of a positive law of this country. There, the court says that he has no right to be assisted. Professor Atiyah and Enonjong have also provided some reasons why this first general rule exists. The reason being due to deterrence as well as to provide for protection of the judicial system's integrity. The second general rule will be that the courts will usually not allow for permanent recovery of benefits conferred under illegal contracts. Next, I will be explaining about illegality under the Malaysian law. So, under Malaysian law, the Contracts Act 1950 is a statute of general application that oversees the contractual relations in Malaysia and offers the guidelines to enter into a contract. Under Malaysian law, the term of illegality does not exist in the Contracts Act. However, Section 2G of the Contracts Act 1950 provides that an agreement not enforceable by law is said to be void. Thus, an agreement will not be enforceable by law if it is illegal or unlawful. A contract will be considered as unlawful or illegal and void if it consists of any one of the following criteria stated by Section 24 of the Contracts Act 1950. Section 24 of the Contracts Act 1950 deals with illegality of consideration or objects of the contract, which would render the contract to be void. This provision reads as follows: the consideration or object of an agreement is unlawful unless A. It is forbidden by law, B. It is of such a nature that if permitted, it would defeat any law, C. It is fraudulent, D. It involves or implies injury to the person or property of another, or E. The courts regards it as immoral or opposed to public policy. In each of the above subsections, the consideration or object of an agreement is said to be unlawful. Every agreement of which the object or consideration is unlawful is void. A contract tainted with illegality cannot be made enforceable. In fact, it is void ab initio, and both parties must not benefit from the said void agreement.
Hi, I'm Kelvin. Now I will be talking about the principle of law before the case of Patel against Mirza. Since the case of Holman against Johnson, a principle has been laid down that if an agreement is in fact deemed illegal, the entire contract will then be void. Lord Mansfield in this case said that the court will never lend its aid to a man who founds his cause of action on an immoral or an illegal act. This principle was then reaffirmed by Lord Gough and Lord Bronnie Wilkinson in the case of Tinsley against Milligan, stating that a claimant will not succeed if his claim is based on an illegal contract. The principle of denying recovery was challenged in Shashan against Al-Kistani as being contrary to the Human Rights Act 1998, and specifically to Article 1 of the first protocol to the European Convention on Human Rights, which reads, "No one shall be deprived of his professions except in the public interest." In the said case, the illegal contract entered into were in breach of United Nations sections on trade with Iraqi citizens. The claimant sought repayment of money lent in breach of this law. Court held that since the unenforceability of a claim on the basis of illegality was not a deprivation of professions within the Article 1 to the ECHR, it was arguable whether the 1988 Act applied at all. However, the cases fell within the public interest exception, so that the illegality defense did not infringe Article 1. If both parties are guilty of entering an illegal contract, but one party has been forced into the contract as a result of duress or undue influence, the contract will not be enforced. But the victim may successfully recover money or property that have been passed subject to the contract. This was affirmed in the case of Hughes against Liverpool Victoria Legal Friendly Society, where there is one illegal contract, but there is a collateral contract that allows a recovery of all or part of the contract. This is of limited utility since a remedy under a collateral contract must not equal to enforcing the illegal contract. A collateral contract must have the effect to protect an innocent party to whom a promise or misrepresentation has been made. This can be clearly seen in the case of Strongman Limited against Sidcorp. The defendant was held liable for breach of a collateral contract, and the claimant could obtain the necessary licenses. In some cases of contract alleged to be tainted by illegality, they were able to disregard the illegality, provided that it does not have to rely on the illegal element. This is shown in the case of Slington against Sullivan. Here, the Court of Appeal allowed recovery of the price under a contract of sale on the basis that the seller could establish liability to pay by relying on the contract itself, but not faulty invoice. The reliance principle has attracted particularly several criticisms. Take a case of hire purchase agreement that is illegal. The plaintiff finance company sues to recover the hired property after the defendant hirer commits a reparatory breach of the illegal contract. According to the decision in Brownmakers Limited against Barnett Instrument Limited, such finance company may recover its property despite the illegality because its claim is based on its title to the property, and it does not have to rely on the illegal contract to prove its claim. The trouble is that, in the above-mentioned case, without proving the illegal contract and its repetition, it could not dare be shown that the defendant's right to retain and use the property had determined entitling the plaintiff to recover the property. In some circumstances, illegal contract remain enforceable by both parties, provided that changes are made by removing the offending parts. Severance is allowed only if it is consistent with public policy that made the contract containing the offending part illegal. If the whole contract is tainted by illegality, then severance cannot save it. The applicable principles were stated in Sadler against Imperial Life Assurance Company of Canada Limited, as approved in Beckett Investment Management Group Limited against Hall. If one party withdraws prior to the illegal part of the contract coming into effect, the doctrine of locus poenitentiae comes into effect. The result of this is that the party who withdraws may recover any money or property subject to the contract. In Taylor against Bowers, Melvis Lord Justice suggested that withdrawal was allowed at the time before completion of the illegal contract. However, in Kelly against Thompson, it was suggested that restitution would be denied once performance of the illegal purpose has started, irrespective of whether it was ever completed.
Hi, I'm Wang Jiahui, and now I'm going to talk about the criticism of the reliance principle. One of the problems of this principle is that one party would gain an unjustified windfall, which the reliance principle does not account for. There would be a windfall to one party no matter which side win on an application of the reliance principle. In the case of Tinsley and Milligan, had Tinsley been Milligan's wife, she would have been unjustly enriched as she would have kept the whole house when she only paid half of its price. In fighting for Milligan, the latter gained what would have otherwise been the windfall of deceiving the government of the subsidy had she not owned up and settled it. This is objectionable because, as Lord Kerr observed in Patel and Mirza, he stated that this gave effect to the illegal agreement between the parties. The parties intended that Tinsley would hold legal title to the house, whilst Milligan defrauded the Department of Social Security, but that ownership of the house would be distributed equally between both of them. This was upheld by the court. It has been suggested that the majority in the case of Tinsley and Milligan was attempting to avoid the perceived unfairness that would result from the application of a strict rule against illegality, which was to deny Milligan on her equitable share of the house when both parties to illegal purpose would be to grant Tinsley a huge windfall. However, there would have been a windfall had Milligan not owned up to her fraud. This conflicts with the concept behind the illegality that one should not profit from his wrongdoing. In any case, enforcing the illegality is objectionable because of two reasons. Firstly, it provides a lever for all similar plaintiffs to use to compel performance from the other side. And secondly, it stretches a safety net below all those engaging in similar illegality. The reliance principle is rendered problematic by these dangers. This windfall problem is made worse by the fact that the reliance principle does not take into account the value of the windfall, which causes substantive unfairness and a disproportionate result. Thank you, that's all for my part, and now I'm going to pass on to my teammate.
Hi, my name is Florence, and I will now continue the discussion of this topic on the facts, the help, and also some principles being established in the case of Patel and Mirza 2016. So basically in this case, Mr. Patel entered into an agreement with Mr. Mirza, whereby he transferred some £620,000 for the purpose of betting on the movement of Royal Bank of Scotland shares, using inside information which Mr. Mirza expected to obtain. As it turned out, the inside information was not forthcoming, and the relevant betting did not take place as well. Mr. Patel then eventually sued Mr. Mirza after his attempts to have the money returned were unsuccessful. A very important point that we can look at in this case is the agreement between Mr. Patel and Mr. Mirza amounted to a conspiracy to commit an offense of insider dealing under Section 52 of the Criminal Justice Act 1993. Mr. Mirza pleaded illegality, arguing that as the contract was illegal, the estory doctrine applied to prevent Mr. Patel from bringing a claim. The Supreme Court, sitting as a panel of 9, unanimously dismissed an appeal by Mr. Mirza. The court split into two factions, with one preferring the reliance test and the other one preferred the policy-based test, with the latter faction prevailing Lords Neuberger, Kerr, Wilson, Lord Hodge, and Lady Hale. Lord Mans, Clark, and Sumption is the minority party in this case. The supporting factions principle will be discussed later, and now we will be focusing on the minority view first. The broad discretionary approach, hereafter the range of factors approach, was met with fierce resistance by the minority. The minority view was that the power of the court to deny recovery on the ground of illegality should be limited to well-defined circumstances. However, on the other hand, Lord Tozen delivered a principal opinion in support of the policy-based test. His lordship said that Mr. Patel is seeking to unwind the arrangement, not to profit from it, and that No particular reason has been advanced in this case to justify Mr. Mirza's retention of the monies beyond the fact that it was paid to him for the unlawful purpose of placing an insider bet. If followed, Lord Curzon said that the policy-based test did not preclude recovery. In addition, Lord Curzon also wrote about that I would hold that a person who satisfies the ordinary requirements of a claim in unjust enrichment will not prima facie be debarred from recovering money paid or property transferred by reason of the fact that the consideration which has failed was an unlawful consideration. The result his lordship indicated was that cases in which a claim in unjust enrichment, with the result that complains that the policy-based test is overly expensive illegality doctrine seem to be misplaced. Furthermore, Lord Curzon, with whom Lady Hale, Lords Kerr, Wilson, and Hodge agreed, held that the essential rationale of the illegality doctrine is that it would be contrary to the public interest to enforce a claim if to do so would be harmful to the integrity of the legal system. So, in order to determine whether this is the case, the court must consider three things. Firstly, the underlying purpose of the law which has been transgressed and whether that purpose will be enhanced by denial of the claim. Secondly, any other relevant public policy on which the denial of the claim may have an impact. And thirdly, is whether denial of the claim would be a proportionate response to the illegality. So now I will pass it to Shakira to tell us more about the principles being established in the case of Patel and Mirza 2016. Thank you.
Hi, my name is Shakira, and I'll be continuing the discussion on the principles of recovery post Patel and Mirza. So, Lord Sumption, on the trio of considerations that was mentioned by Florence just now, said that they are far too vague and potentially far too wide to serve as the basis on which a person may be denied his legal rights. It converts a legal principle into an exercise of judicial discretion while showing all the vices of complexity, uncertainty, arbitrariness, and lack of transparency. It may also be dangerous to be applied because the majority did not identify reasons why insider dealing was considered a crime, or explain why this was relevant to determine how the defense applied. Neither were any policies identified which would be affected if the claim was denied, nor was the question of proportionality considered explicitly. However, Lord Sumption's approach does not stand up to scrutiny. If it were the law, it would produce results that no legal system would tolerate. By buying into a rigid rule-based approach, there is no room for maneuver where one cannot take account of factors such as the purpose of illegality, the parties' respective culpability, and the seriousness of the illegality that are simply unavoidable if one is to reach satisfactory results. Lord Curzon's response to the trio of considerations was to acknowledge that they might result in uncertainty, but he considered that the existing law was already driven with uncertainties. And anyway, certainty was not a relevant consideration when dealing with people who were contemplating unlawful activity. The minority judges were keen to stress that they were not applying a novel and fresh approach. They did not shrink from accepting that they were developing or reinterpreting the existing rules and exceptions. In terms of no reliance principle, Lord Justice Gloucester and the Law Commission recognized that the rules themselves are complex, uncertain, and fluid in application. The rule can lead to results that could be explicable on technical grounds, but does nothing to further the policy of the underlying legal prohibition. According to Andrew Burrows, in his journal, Illegality after Patel and Mirza, the new approach is to be applauded for three main reasons. Firstly, the no reliance principle approach is uncertain in scope and effect. Secondly, application of the principle depends on how the plaintiff pleads his case. If he correctly pleaded, he would succeed without any consideration whether the policy underlying the prohibition is advanced or stultified by allowing his claim. Thirdly, The outcome of cases involving apparent gifts in transactions tainted with illegality depends on the type of relationship between the transferor and the transferee. The majority held that the no reliance principle of Bowmakers Limited and Barnett Instruments Limited and Tinsley and Milligan should no longer be good law, and there was no need to refer to the locus penitentiae doctrine in deciding the outcome. Their decision was based on the public policies involved and proportionality. However, according to Lord Sumption, the reliance rule or test remains the correct approach to illegality. On the criminal part, it is better to restore the parties to their original position rather than to allow the defendant to profit by retention of the enrichment. This was expressed more clearly in the judgment of Lord Newburger, who identified what he called the rule that the claimant is entitled to the return of the money which he had paid, even where the contemplated illegal activity had been performed in whole or in part, because the law should not regard an inherently criminal act as effective consideration. Lord Tolson suggested that there will be some circumstances where the nature of the illegality will defeat the claim, such as drug trafficking. Illegality prima facie provides an ironclad defense to both enforcement claims and restitution claims.
Hi, it's me again. I would also like to talk about the criticism of the new approach. The question is that, does the new approach promote certainty? Lord Clark expressed his corresponding view in opposing and criticizing the new approach that the new approach is far too vague to serve as the basis on which a person may be denied his legal rights. It converts a legal principle into an exercise of judicial discretion, in the process exhibiting all the vices of complexity, uncertainty, arbitrariness, and lack of transparency, which was attributed by Lord Tolson, who was the judge of the Supreme Court, to the present law. However, Lord Tolson attempted to defend this uncertainty in his judgment. Firstly, he retorted that the existing law, which he said was doctrinally riven with uncertainties. Secondly, he mentioned that he was not aware of uncertainty in other jurisdictions that had adopted the relatively flexible approach to illegality. Thirdly, whilst commercial transactions need certainty of the law, the same consideration does not apply to people contemplating unlawful activity. In such cases, discovering where the public interest lay was more important. Lord Tolson's third argument was supported by Lord Kerr, who said that the uncertainty or predictability of outcome may be suitable for those who seek resolution on honest disputes. It is not necessary to those who engage in disreputable conduct. Thank you, and that's all for my part.
In conclusion, the general rule is that the court will not enforce a contract which is illegal or which is otherwise contrary to public policy. Where illegality arises in the performance of a contract which was valid at the moment of formation, the contract can be enforced by the guilty party only when it was not the purpose of the statute broken or the common law rule violated that the contract should be invalidated. In the case of the innocent party, the contract can generally be enforced by him where he had no knowledge of the illegality. A contract is illegal if its formation is expressly or impliedly prohibited by statute. The general rule on recovery pre-Patel and Mirza is the courts will not permit the recovery of benefits conferred under an illegal contract, but recovery will be allowed where the parties were not in pari delicto, where the claimant has effectively repudiated the illegal purpose, or where the claimant can establish his right to the money or the property without relying upon the illegal nature of the contract. On the other hand, Malaysia follows the common law principle regarding this matter. Pre-Patel and Mirza, the court has developed a new principles of recovery. In determining whether the essential rationale of the illegality doctrine is that would be contrary to public interest to enforce a claim, if to do so would be harmful to the integrity of the legal system. The court must consider three elements. The first element is the underlying purpose of the law which has been transgressed and whether that purpose will be enhanced by denial of the claim. Secondly, any other relevant public policy on which the denial of the claim may have an impact. And lastly, whether the denial of the claim will be proportionate to the illegality. This trio of consideration is too vague, uncertain, and lacks of transparency. Nevertheless, in terms of no reliance principle, the new approach should be upheld for three main reasons, such as the no reliance principle approach is uncertain in scope and effect. Secondly, application of the principle depends on how the pleading was made by the plaintiff. Thirdly, the outcome of the cases involving apparent gifts in transactions tainted with illegality depends on the type of relationship between transferor and transferee. On the other hand, for criminal cases referring to the judgment by Lord Neberus de Rule, the court decided that it would be better to restore the parties to their original position. In the words of Lord Clarke in expressing his view regarding whether or not the new approach promotes certainty, he said the new approach is far too vague to serve as the basis on which a person may be denied his legal rights. Lord Tolson's counter-argument was that the existing law was doctrinally riven with uncertainties and he was not aware of uncertainty in other jurisdictions that had adopted a relatively flexible approach to illegality. Subsequently, he said commercial transactions need certainty of the law but differs when it involves unlawful activity. The third view was supported by Lord Kerr that goes on and said that certainty or predictability of outcome may be suitable for those who seek resolution on honest disputes, if it's not necessary to those who engage in disreputable conduct. To sum up, Patel and Mirza definitely resolved the disagreement in English courts as a proper approach to be adopted towards the illegality defense. In regards to the trio of considerations and other factors approach, will bring clarity in this matter still remains unclear. Hello everyone, my name is Dina and I will be explaining to you about pre-Patel and Mirza Malaysian position. By virtue of Section 3 of the Civil Law Act 1956, Malaysia adopts the common law principle. However, the principles under illegal contract are governed by the Contract Act 1950. Section 24 of the Contract Act 1950 states that in each of the above cases, the consideration or object of an agreement is said to be unlawful. Every agreement of which the object or consideration is unlawful is void. Section 2G provides that a void agreement is not enforceable by law. However, in some circumstances, Malaysian law allows restoration of advantages received under an illegal contract. The common law principle that the parties are not equally at fault may recover under an illegal agreement is said to be embodied in Section 66 of the Contract Act 1950 when an agreement is discovered to be void. Therefore, when a party to an illegal agreement seeking to rely on Section 66 must not be aware of the illegality when the agreement was made, but only later on discover the illegality. In the case of Eng Susan and Menaka, the parties were not aware of the illegality at the time when the contract was made. It was discovered to be void only after several proceedings had been started. Hence, Section 66 of Contract Act 1950 apply. This can be distinguished with the case of So Eun Keng and Lim Chin Hua, where the both parties were aware of the illegality at the time the agreement was made. The court held that Section 66 of Contract Act 1950 did not apply and let the laws lie where it fell. Malaysia's court follow the common law principles under this reliant principle. This is seen in the case of Sarjan Singh and Sadara Ali. Here, the defendant did not rely on the illegal contract for his claim, but on his title. Therefore, his claim was allowed. Similar to English law, restitution may be available where one party withdraws before the illegal purpose is carried into effect. In the case of Palanapia Chetia and Arunasalam Chetia, the court did not allow this defense to be raised as the fraudulent purpose as actually been affected by means of the colorable transfer. There is no room for repentance.